obviously the future. So we're going to focus on a couple of areas where colonization is intersected with threatening the futures of children. So we're going to focus on discussing self-determination, destruction of environmental resources, lack of protections for healthy childhood, and gender-based violence. Ultimately, we all agree on this panel, even though we have different perspectives, that a healthy environment and community is critical to protecting Indigenous families and the future of their children, which of course is the future of Indigenous governments. So we're going to look at both. We're going to identify some problems in different areas that go to this theme. And then ultimately we will consider both domestic, focusing on the United States, and international solutions to securing Indigenous futures. So I'm going to briefly introduce our speakers, and then going to turn it over to them for their presentations, and then we'll leave time for any questions that they may have. So my name is Elizabeth Kronk-Warner. My pronouns are she and hers, and I have the privilege of being a citizen of the Sault Ste. Marie Tribe of Chippewa Indians and the dean at the S.J. Quinney College of Law at the University of Utah, and my research focuses on the intersection of environmental and Indigenous law. The first of our speakers will be Lauren Shiftgaard, who is Cochiti, Pueblo, and she is a research fellow at UCLA Law School. And she's going to start us off by first taking a little extra time just to situate the conversation and to give an introduction to the histories of Indigenous peoples that are relevant to our discussions today, so we can just have that baseline introduction. And then she's going to go into a discussion of gender violence, specifically how it intersects with this question of securing futures for Indigenous peoples. Then we will have Neoshia Roemer, who is an assistant professor at the University of Idaho School of Law in the United States. And she's going to continue this trend of talking about how we can intercept this violent remnant of colonization, specifically in the context of family regulation and child welfare. Next, we have Heather Tanana, who is Dene, and she is an assistant professor and Wallace Stegner fellow at the S.J. Quinney College of Law at the University of Utah. And she's going to talk about environmental resources, specifically securing a human right to water. Obviously, children and Indigenous families are so very important to this discussion. And last but certainly least will be me, and I will talk specifically about how this topic intersects with climate change and how climate change is impacting the future and how it relates to colonization. So with that introduction, Professor Way.
Thank you.
Oh. All right, there we go.
Sound okay?
Yes.
Awesome. Thank you. Thank you so much for having us, and apologies I can't be there in person. Your glowing skin makes it look amazing. So at least from here, it looks great. I'm Lauren Van Schilfgaard. And so I wanted to talk just a little bit about where tribal sovereignty is situated in the United States, which then informs the ways in which tribes can respond to these varying issues with varying degrees of success. And so tribes have some recognized sovereignty under US law. Tribes have been able to build their own law, and we're doing so pre-contact and are certainly continuing to do so post-contact, a kind of clunky, complicated way that certainly I don't think is intentional, nor is it very efficient. Or at least leading up to the American Revolution, tribes engaged predominantly on the East Coast, but certainly in what's now the Southwestern United States as well, engaged in diplomatic relations with the different European nations that they encountered. It's also true that the different European nations had different styles of colonization. And so tribes had to enter into varying types of relationships depending on whether they were engaging with the Dutch or the French or the British, which had a very separation style of colonization versus the Spanish, which had a very, we're going to build a church in the middle of your community and integrate in a very forcible way that was, all of which was not great, but very different and produced different styles of recognized sovereignty under what would become the colonizers' laws and terms. Post-American Revolution, we sort of trace the history of relations with the nation state as sort of starting on the East Coast and moving west, because that's how we frame US history. But of course, if you're a tribe situated in the Pacific Northwest, say in Washington or Oregon, or in the Southwest, that history include encounters with multiple different colonizers, including maybe Russia for our Alaska Native village relatives. But under US law, this is where we get the first iteration of recognized tribal sovereignty under US law. The United States carried forward the diplomatic relations that the British Crown had been establishing, including the use of treaties, which under British law and then later US law was a nation state to nation state tool that inherently recognized the sovereignty of the other treaty-making partner and was a negotiation for various terms under international law. Treaty making continued with tribes up until 1871, which in that time in the late 19th century, we saw a real pivot in those relations. In the early 19th century, we saw a series of cases in the US Supreme Court, the highest court under American law, that solidified, at least for a time, what tribal relations were going to be. And so I think it helps frame what today we think of as tribal sovereignty and where it's most useful to look to international law for how it can support Indigenous rights. Under US law, tribes are recognized as separate governments that operate outside of the US framework. They're considered extra constitutional, and so their sovereignty operates in a way that's very distinct from the states like California or New York that derive their sovereignty from this constitutional document. Tribes are different. They are recognized as existing in a separate way whose sovereignty is distinct from the US. That's great, that's cool. However, US law simultaneously has rung in tribal sovereignty. In a phrase that's still used today that was coined in these early 19th century cases, tribes are considered domestic dependent nations. They're nations, separate sovereigns, but they're considered lesser than a foreign nation state that operates wholly inside the United States. From an international law perspective, this is incredibly problematic. Tribes are not considered sufficiently sovereign or separate for purposes of, say, participation in the United Nations, or able to engage in foreign nation-to-nation relations with other nation states. We have to go through the nation state. We are considered totally inside the nation state. And to the extent that tribes are engaging in the international forum, we have to go through our nation state, the United States, in order to have true representation, which may or may not be effective. Tribal sovereignty has subsequently been diminished in a variety of ways. We see this prominently in land rights. Right out of the gate, from a legal perspective, Aboriginal title was demoted, wasn't considered full fee simple in a really problematic racist way that definitely needs to be addressed in US law. But tribes were also forcibly removed. Tribes had their negotiated land or reservations, that is frequently known in the United States, can be unilaterally diminished by the United States, and a number of clearly uneven power dynamics in which tribes have recognized rights in the United States, but the United States retains the authority to change the terms whenever they want. the United States recognizes tribes as governments, but can terminate that recognition whenever it wants, and did so with fervor in the 1950s. Now, that being said, the flip side of this is up until the moment that the United States does unilaterally destroy any recognition of tribal rights, the presumption is that those tribal rights do exist. Treaty making may have ended in 1871, but all the treaties made up until that point are considered still good law under the United States. And we most recently saw in 2020 recognition of those treaty rights that survive, and that was in the McGirt case that recognized the continuing validity of the Muskogee Creek Nation Reservation that was established pursuant to a treaty negotiated between the Muskogee Creek Nation and the United States. Great, simple, basic. Until the United States says otherwise, this is good law. Because of this uneven power dynamic, there has been a doctrine developed to sort of recognize the disparity there. And that is, in theory, to the benefit of tribal sovereignty. The United States is recognized to have a federal trust responsibility, an obligation to operate in a way that acknowledges tribal sovereignty. And again, if there's any vagueness, any ambiguity, interpret that ambiguity in favor of tribal sovereignty as a recognition of this, what's been characterized as a ward-guardian relationship, that tribes exist within the United States, and because they're extra-constitutional, because there's no formal representation in the federal government, such as, say, a representative in Congress or the Senate, instead, the US government has a trust responsibility to tribes. So the result today is that we have a tension. There is a recognition of tribal sovereignty and a reciprocal obligation, a responsibility to operate in ways that benefit tribes. But the US government retains the settler colonial power in which they can do whatever they want, and in fact, have done whatever they wanted, including to the detriment of tribes. The federal government recognizes an obligation to interact with tribes in a sovereign to sovereign way, but has a really clunky, if not non-existent way of doing that. We use the term consultation here, but there's no uniform way to engage in that, nor is there a formal mechanism for a tribe to say, file a lawsuit with a cause of action for failure to engage in consultation. That doesn't exist. We have vocal lip service that we live in a self-determination era in which the United States recognizes Indigenous sovereignty, but we're also clearly living in a context of a hostile US Supreme Court that is very willing to diminish tribal rights whenever they see fit, and an inept Congress that seems incapable of standing up for tribal rights. So the result really is that tribal sovereignty exists in theory in the United States, but is clearly very precarious, completely at the whims of the settler colonizer United States, and really begs the question, what can international law do to help shore up Indigenous rights that provide some stability beyond just the whims of the United States? Should I transition right into gender-based violence? Okay.
Yes, please do.
Cool. So now we'll go into some of our subject matter things, specifically as they relate to children. And I get the honor of discussing gender-based violence, which basically is a direct result of this precarious nature of sovereignty, is hugely problematic in the United States. We finally have some verbiage now, thanks to incredible advocates that have been working for lifetimes over to really bring light to these issues. And so we now refer to it as the Missing and Murdered Indigenous Persons Crisis. It's really difficult to overstate the severity of the crisis in the United States. International bodies have actually brought attention to the extent that this is a crisis, most notably Amnesty International, which has now issued 2 different reports honing in on the United States and the fact that this crisis exists. Native people are subject to violence at wildly disproportionate rates. A huge extent of that violence is sexual violence. 1 in 3 Native women will be raped in their lifetime. That's impossible to imagine. It means that all of us personally know someone, if not ourselves, that has been subject to this violence. It's also very different types of violence than the rest of the population is experiencing. Unlike any other racial category in the United States, Native people suffer sexual violence from persons of a different race. That's sort of funky, but it's also clearly an indicator of the extent to which colonization has been wildly successful in the United States. 1491, Indigenous people were 100% of the population of the territory that is now the United States. Today, it's closer to 2%. And so that is also a number that's just really difficult to envision. That being said, Native people are incredibly resilient. So what led us here? Why is there such a crisis? I think in this legal panel, we would argue there are legal reasons that have contributed to this. And in fact, there is significant research to suggest that the legal structure in which tribal sovereignty operates has produced or at least exacerbated this missing murdered Indigenous crisis. Going back to those early 19th century cases that established the initial framework, recognizing tribal sovereignty, albeit in a diminished form, part of that recognition was that, all right, tribes exist within the United States and they're just going to have to deal with the United States, but tribal territory is recognized. And we are going to recognize the right of tribes to self-govern, to make their own laws, specifically to the exclusion of the states around them. That's a big deal. I think that is the exact framework that the moment that Justice Marshall said it in 1831 in Worcester v. Georgia, tribes have been fighting ever since to preserve. So the idea is that tribes have territorial jurisdiction that includes criminal jurisdiction to hold accountable perpetrators that commit crimes in their community. That includes both against their own tribal members as well as outsiders, including non-Indians that may come in with nefarious intentions or reckless behavior that produces criminality. Pretty immediately, the federal government inserted itself, providing itself concurrent jurisdiction. That's true today. Starting in 1817, the federal government says we're also going to operate jurisdiction here, and they pretty much have ever since. So what you have, unlike most other jurisdictions in the United States, where if you go to the state of Arizona and you commit a crime, Arizona has territorial jurisdiction over you, including your person, regardless of whether you're a resident or a US citizen or a non-US citizen. If you're there and you commit a crime, Arizona has jurisdiction over you. In, quote, what we call Indian country, which is the legal term of art for tribal lands, we have multiple jurisdictions asserting their authority in a really complicated framework. So it's complicated, that's not good. At the same time that the federal government is asserting its authority, we also have the state asserting its authority, claiming jurisdiction over certain persons, predominantly non-Indians. And so we're immediately seeing in the criminal framework a diminishment of tribal sovereignty that is no longer akin to their state counterparts. As the 20th century rolls along, we also see a decay of tribal sovereignty, the ability for tribes to assert their authority in an effective and comparative way. We see this in different moments. In the 1950s, we see like big attacks on tribal sovereignty. So like tribes are just getting deleted off the list. We see forced relocation in which lots of tribal members leave their tribal lands and move to outside entities. In the 1960s, ironically, as part of the civil rights movement, we have the Indian Civil Rights Act, which is cool, recognizing that tribal people are people that deserve rights, but it's at the expense of tribal sovereignty. There's this imposition that tribes need to be restrained. And this is most prominently seen in a sentencing limitation. Overnight, all tribal courts are demoted to misdemeanor courts. That's still true today. Tribes operate robust criminal justice systems, but can only ever sentence someone to up to a year imprisonment. And so it's only ever going to be as robust as it's going to be. And then we start to see, starting in 1978 and through like June 2022, a incorporation of a doctrine known as implicit divestiture. This is, I think, one of the most modern day problematic issues that tribes currently face, and for which we need international instruments to help shore up what remains of tribal sovereignty. The US Supreme Court has argued that as a product of colonization, tribal sovereignty is decaying over time. And they interpreted in 1978 that this decay meant that tribes no longer had the authority to prosecute non-Indians for anything. That includes if they commit sexual violence or child abuse against a Native person in Indian country. It's unbelievable that this is the case. And so Amnesty International comes in and points specifically to this, saying, yeah, you have a missing and murdered Indigenous persons crisis, in part because tribes are no longer allowed to respond to anybody and are now dependent on federal governments and state governments to exercise their concurrent jurisdiction to hold these individuals accountable, but aren't. We have huge declination rates in Indian country, basically refusals to prosecute, which means it is open season and people know about it. Perpetrators have admitted that they intentionally target tribal communities because there is this jurisdictional gap that basically means that there is no accountability whatsoever. In response, I mentioned that Congress has been tepid. There have been some responses. In 2010, in the Tribal Law and Order Act, Congress recognizes like, wow, tribal courts exist, but they're only misdemeanor courts. Maybe we should boost that up. They did kind of. They enhanced the sentencing limitation from 1 year to 3 years, which is like, oh, wow, 3 years for rape or child abuse. But tribes can only ever exercise that if they further assimilate their tribal courts into an American model, which even if they want to, has proven to be very expensive. And so only about 40 tribes have been able to take advantage of this, which is out of 574. So this has not been a huge game changer. Similarly, Congress recognized, specifically in response to the missing and murdered Indigenous persons crisis, the bell that Amnesty International rung and the cry that Indigenous people have been making for certainly decades, if not hundreds of years, recognized like maybe we need a fix to this problem in 1978, where we said tribes can't prosecute non-Indians. We're going to fix that. But like the Tribal Law and Order Act, Congress only did this in a very small way. They've recognized it a few subject matter areas where tribes can exercise jurisdiction, thankfully including domestic violence and dating violence. They did this in 2013, and when they did it, they only did it for domestic violence, which means they didn't provide jurisdiction for rape, for sexual assault, which is a problem. They also didn't provide jurisdiction for child abuse or for child neglect, which in a domestic violence context, like even if we're just looking at domestic violence, children are part of the family. They're part of the domestic household. And yet tribes were still barred from being able to protect their own children. Huge problem. But thankfully, in 2022, we saw a fix for that. Tribes haven't been able to, this doesn't go into effect until October, but at least with 2013, like the Tribal Law and Order Act, it's proven to be really expensive for tribes to take advantage of this. Turns out, after 450 years of having your criminal justice systems specifically targeted for destruction, it's hard to build them up, especially in the likeness of an American court, which I don't know if this is well known, but on the International Forum, the American carceral system is critiqued for maybe not being the most effective system, and yet tribes are compelled to mimic that system. But we'll see. There's at least recognition that there's a problem. So, acknowledgement is the first step. But that's all to say, it's not a great system. Then, what's it been? Has it been 2 weeks? We had a decision out of the US Supreme Court in Castro Huerta that, in the same vein as what we saw in 1978 in the Oliphant case, destroying tribal authority to respond to non-Indians, we saw an expansion of state authority in contradiction to tribal rights. This was in the Castro Huerta case. This case just came out. It is widely recognized as being an incredibly poorly reasoned and nonsensical case. And yet that's not the first time that's ever happened in Indian law. And it's probably not going to be the last. And yet it is a very disturbing perpetuation of this argument that tribal sovereignty is decaying in the United States. In the long run, that's a big problem. We need international help to prevent this argument that tribal sovereignty is decaying. We're a growing population, not a dying out one. But in the short term, it's extremely problematic because the people that are going to bear the brunt of this, like it's always been, has going to be Native victims of gender-based violence, predominantly women, but certainly all vulnerable populations, including the Two-Spirit community, as well as children. And it was wildly unacceptable in past generations. And the fact that this is still a crisis now is just blood boiling. And there's much work left to be done.
Thank you. Professor Roemer?
Hello, everyone. I actually had planned to start. My name is Neoshia Roemer, by the way. I'm here to talk about family regulation and child welfare. I had planned to start talking a little bit about family regulation and child welfare, but I think there's an important point that Professor Van Schilfgaarde mentioned, which is American Indian population is a growing population. I think in the last 2 decades, American Indians have gone from 1% of the population on the US census data to 2%, which for some that's a small percentage, but what I'm going to talk about illustrates not only is that an important number, not only is that growth important, but why it is that we need protections for children to keep that growth going. So you may notice that maybe you don't notice, but I'm talking about family regulation and child welfare, as Dean Kronk mentioned. Family regulation and child welfare, there are two things that are very similar. In fact, family regulation encompasses child welfare. The reason that some modern advocates and scholars are going to use the phrase family regulation has to do with how our child welfare system has been deployed in the US. So in the United States, historically, and even today, we still see this, the child welfare system has been deployed against our Indigenous population in a way that's extremely heavy-handed, often without the proper procedure involved. So prior to 1978, when the Indian Child Welfare Act was enacted, there were no real restrictions on child welfare, meaning state involvement in this case. So what we saw prior to 1978 were several different attacks on our Indigenous communities that first started with this idea of sending children to boarding school. This started in the late 19th century. Children were either coerced from their homes. In some cases, communities voluntarily sent their children before understanding what these schools were actually about. We saw a lot of coercion where necessary aid to live, such as food and other commodities, were denied to communities unless they would send their children to these schools. And we also saw some other, I wouldn't even call it coercion, just tactics in which children were removed. And in these schools, the idea was, as the first founder of the first Indian school, the Carlisle Indian School, stated explicitly in 1879, the idea of these schools was to, quote unquote, kill the Indian and save the man. So this was an out and out cultural genocide project. Now, the phrase cultural genocide didn't exist in the 1880s, but I think it's important that we talk about it, especially since a national boarding school report funded by the federal government just came out a few months ago. I think it's important that we use the proper language for what that was, because in these boarding schools, children were removed far away from their homes. In some cases a little bit closer to their homes, but they were not permitted to use their Indigenous languages. They were not permitted to participate in their Indigenous religious practices. In some cases, they couldn't even speak to their own siblings who were at the school. The whole point of this exercise was to break these children down, to make them non-Indian, to make them assimilated. Because as Professor Van Schilfgaarde pointed out, the numbers of American Indians or Indigenous folks in the US has been low. And this is why it was so low. Because these assimilationist policies were created for that exact thing. Remove children, cut off that line to culture for those children, but then also cut off the membership of our tribes. So we have the boarding school era, and I mentioned the cultural genocide piece. These boarding schools were brutal for children. They face immense amounts of physical, sexual, and mental abuse. And not only that, they weren't actually schools, at least not schools in the way that we think of school. The children were forced to learn and speak English. We saw a lot of division of gender-based labor. So for example, girls were forced to go and learn how to do traditionally female-oriented labor. So household tasks, ironing, making clothes, cooking, those sorts of things. Whereas male students were sent to the fields and learned agrarian tasks. Now, some people may think about this in terms of, well, in the late 19th century, that type of trade school model was probably good for kids because they were learning how to do tasks they needed to do. Now, I mentioned before that there were some tribes who voluntarily sent their children to the schools before learning about what they actually were. The reason that those folks sent their children voluntarily to those schools was to gain knowledge, for the reason that parents in the 21st century send their children to school. That type of schooling didn't exist for many of these children in these schools. And so this also led to, in some of these schools, some of the children were just simply farmed out. And, there's been a lot of discussion about these farming out labor processes, especially as they happen to incarcerated individuals, incarcerated African Americans in the US. But there was a similar system for Indian children to be farmed out, to go and provide labor instead of receiving an education. And again, part of this was assimilationist. And there was this drive led by the federal government to assimilate these children into an Anglo-American lifestyle, cut off their ties to the tribe, and eventually, as we get to the 1950s, start terminating tribes, using claims that, well, you don't have enough membership, getting rid of tribes, and that severs the responsibility that the federal government has, because yes, the federal government does have a trust responsibility to these tribes. So that covers the period from the late 19th century up until about the mid 20th century. In the early to mid 20th century, to add insult to injury of the boarding school program and everything else that's happening, we start seeing adoption as the solution for Indigenous children. There was even a nationally led Indian adoption project. Now, the reason that we talk about this is not necessarily to say that adoption is the worst thing that could ever happen, but the way that adoption was deployed against our Indigenous communities was a weapon of violence. It was a weapon, because what we saw in the era prior to the 1970s were families being coerced to either sign over their children for adoption, or essentially state welfare workers, and in some cases religious organization workers, showing up and removing the children from the home forcibly. In many of these cases, there were no documents. There was no, what we would consider today in the US to be the proper procedure, because today in the US, and this is in large part thanks to the Indian Child Welfare Act, there's a whole procedure. Parents are afforded the rights of due process if the state believes that there is abuse and neglect, and there are proceedings in which the court is supposed to support reunification between the parent and the child. That did not happen prior to the 1970s. In fact, when Congress was considering passing the Indian Child Welfare Act in the 1970s, some of the testimony they heard was from Bertram Hirsch, who at that time was a very young attorney. And he had gone to work in, I apologize, I'm from the US, but I always get my Dakotas mixed up. I believe it's North Dakota. He had gone to work in North Dakota and had noticed a pattern in terms of the clients he was representing. Just people who had no idea of why their children were removed. One story that is in the legislative history is of a woman who had 2 of her 3 children removed for over a year for no reason. No notice was given to her about court dates, no petition or anything like that. And that's a pretty big deal. Because even as the Convention on the Rights of the Child, which came into being much later, notes, every parent and child is entitled to process. And so many of these folks had no process, and that was on purpose, because many of the beliefs at the time still involved that notion of kill the Indian and save the man. I apologize for that violent phrase. Those notions still existed. And part of this was, if we adopt children to the right parents during this adoption boom after World War II, those children will grow up in a way that, they won't have those ties to their Indigenous culture. They won't have the ties to their language. They'll be Americans, not Native Americans, as some people, or as some people refer to our Indigenous population. So in all of that, we have these very brutal policies. And by the way, I don't think that in this setting, I could ever even give you the full extent of how brutal these populations were, or excuse me, how brutal these policies were, and how they explicitly tried to destroy our Indigenous populations. There aren't words. I really encourage you to read testimonies, to look at the legislative history, or just listen to people talk about it. Because today, many of those adoptees and people who attended boarding school are talking about their experiences. And, something that is very hard to be or to recognize in academia is that those oral histories matter very much, even though they're not written down in our textbooks, or, we don't have law review articles about them. Those stories are there. And it's very hard to do them justice in this short period of time, and the trauma that they cause not only individuals, but also the trauma they cause tribal communities at large. So in the 1970s, there's some movement from the American Association on Indian Affairs, along with other groups, to push for a federal law that would protect Indian families and communities. And so in 1978, Congress enacts the Indian Child Welfare Act. That's still good law in the US today. I want to point that out, and I will probably say that several times in the following conversation. But this law has what I would consider it's a two-pronged purpose. First off, Congress has a trust responsibility to tribes. As part of that trust responsibility, the logic states that part of that trust responsibility is ensuring that tribes can continue, right? That tribes can have a membership base. So part of ICWA is recognizing that federal relationship between tribes and the government. And that is sort of the legislative hook that we use in the United States under US law to say that Congress has the right to pass this law. But also, it's about parents and families and making sure that Indian peoples or Indigenous peoples in the US have the right to maintain their family, to choose when to have children, to choose not when to have children, and to maintain their families outside of a system that has been used for years to target Indigenous peoples. So the Indian Child Welfare Act, as I said, in terms of, the acknowledging that trust responsibility that Congress has with the tribes, it vests interests in, or excuse me, I shouldn't say it vests interests. It acknowledges that tribes have interests in their children. And it does so in two specific ways. First off, actually 3 ways. First off, it allows tribes to intervene, legally intervene in state child welfare proceedings, meaning that tribes get to participate as a party. They get to have a say in how their children and how these child welfare cases go, because these are their members. Second, it has a mechanism to allow tribes to exercise their full sovereignty by transferring certain cases to tribal court where necessary, where possible. I'm giving you just the broadest strokes here. There are a lot of ways in which these measures can be, there's a lot of workaround in terms of these measures. But finally, it allows tribes to make sure that they're finding their Indian children. Because as Professor Van Schilfgaard noted, some of the policies used in the 20th century, particularly termination, relocation, and then some tribes have since become re-recognized. It's made it very difficult for tribes to, well, I should frame it in terms of individuals. It's made it difficult for some individuals to keep those ties with their tribes. Because, for example, if your tribe is in Oklahoma, but your family was forced to relocate to California, you may not have been enrolled in your tribe. In some cases, we see people who know that they are Indigenous. We see this quite a bit, I believe, in Washington State, where they know that they are tribal members. They know that they are from Alaska, but they're not entirely sure which village they belong to. So we have processes in ICWA that allow, and actually I shouldn't say allow, require state courts to do some of that work in helping people or helping tribes identify their members, I should say. So that I think is the federal legislative piece. But the piece that applies to individuals is that, and I'm going to back up just a bit here. United States family regulation system is notorious for using biased practices, particularly, I will be very blunt, racism and anti-poverty measures. And unfortunately, many of our Indigenous families who come before the family regulation system meet both of those criteria. So people who are of color in the United States and poor, when they have these interactions with the family regulation system, we know that, you know, simply being poor, while not codified as abuse or neglect, can usually mean that the state finds abuse or neglect. And so to kind of back that up and explain what I mean, there's been a lot of research over the years that talks about some of the issues with our neglect laws specifically. But for many poor folks in the United States, they may not be able to provide adequate supplies for their children. So, you know, adequate food, adequate housing, adequate clothing. Now there's a lot of debate over, well, how do we get that? How do we fix that? The issue here becomes that the family regulation punishes those parents. Not being able to provide for your child because of poverty, because of where you live, because of your own disabilities, any of those things means that, you know, you could have your child taken away. It's a form of criminalizing poverty. And we've seen time and time again that Indigenous peoples are targeted in that system. In fact, we still, I'm going off the most recent data that I have in my head, we still see American Indian children in the child welfare system at a rate of 3 times that of white children. Even with this Indian Child Welfare Act in place, Indigenous families are still coming into the system. It's traumatic for those families to be in that system. You know, a great example that my mentor often uses is, you know, imagine being a parent who forgets that it's your day to pick up your child. So instead of picking your child up at 3 o'clock when the school lets out, you get a call at 3:15 from the school saying, hey, come pick up your child. And you're like, oh my goodness, I forgot. And you get there at 3:30, you know, no harm done. Maybe the teacher has to write a note in the file, or, you know, some schools are different. But the point here is that for most of us, there's no harm done. It's just, oh my goodness, I can't believe I forgot. If you're a person who's currently involved in our family regulation system, that becomes a huge deal because you are constantly being watched. You are constantly under surveillance, making sure that you are a good parent. You know, if you get a flat tire on the way to visitation and you miss the visit, that's something that can, you know, that's first off, that's something that happens to a lot of us. But second off, that's something that can easily work against you in terms of reunification. So the system is very brutal towards any parent and child who is involved in it. But it's also especially brutal for Indigenous communities when you start to factor in things like, you know, a lot of our Indigenous population, not all, but quite a bit of our Indigenous population is focused in the Western states, where there's just a lot of broad open country. You know, we've had stories of, we've listened to stories of families who've been separated from their children and have had their children placed hundreds of miles from them. But I will point this out as well. Even if your child is only 20 miles away from you, if you don't have transportation, because you don't live in a city, it may as well be 100 miles. So we see a lot of issues in our current family regulation system. Some people are probably knowledgeable as to how that system impacts African Americans, because there's a lot of literature on that. We see a lot of the same patterns as to Indigenous peoples, but I will point out that this historically has been a form of cultural genocide when applied to Indigenous communities, because there is that, even though we may have left the policy as spoken behind, but it doesn't seem like we've left the policy itself behind. So briefly here, I will talk a little bit about where we are with the Indian Child Welfare Act today. So the Convention on the Rights of the Child does mention that children have the right to their identity. I meant to mention that a little bit ago. And the Indian Child Welfare Act continues to promote that connection to identity and try to protect that connection. However, that angers quite a few people are angered by that. Now you might be going, Professor Roemer, how could you make that assertion that quite a few people are angered by that? Well, the provisions of ICWA, that's our colloquial name for it. The provisions of ICWA that are most often challenged are the adoption provisions. We currently have a case pending before our US Supreme Court in which 3 separate adoptive couples in 2 states are suing the federal government on the grounds that ICWA is unconstitutional. Now, some of these children started out as foster children who were not able to reunify with their parents for whatever reason. And one of the children was a voluntary adoption, meaning that the mother and the father, in this case, agreed that they would put the child for adoption. So why this matters is adopting these children out keeps them away from their families. It keeps them away from their identity, from their cultural ties. It doesn't allow for them to develop that piece of themselves. Now, one thing that ICWA does, and why child welfare advocates all throughout the US, even advocates who don't work with Indigenous communities, what they love about it is the idea that it, 1, promotes family reunification, and 2, it has placement preferences that just make good darn sense. Those placement preferences state that if a child is removed from their home in foster proceedings and or adoptive proceedings, there's 2 different subsections in the statute. The first place you look, well, first off, you consult with the child's tribe, but the first place that you look for a placement is with family. And that makes sense because we know children thrive when they are with family. Children tend to thrive when they're in community. That's what the placement preferences of ICWA does. However, those challenging the law consider that racist because what their argument is that it basically says a non-Indian can never adopt an Indian child. And friends, that is not true. Because what ICWA does is it prioritizes family placement. A large portion of our Indigenous population in the US is mixed race, meaning that some children have parents who, or have family who are members of tribes, and they also have family who aren't members of tribes. And so those children who have mixed race families like that, either any family member has the right to seek placement of that child. It doesn't matter that the family member is a white person. I actually, have worked with people who are non-Indian who have received, custody and later adopted that child. It's about prioritizing family. And by the way, I said, mixed race. I think it's also important to note that in the US, American Indian or Indian has a legal meaning. Under the Indian Child Welfare Act, the meaning of Indian is someone who is enrolled in the tribe or is eligible for enrollment with a parent who's enrolled. So this act applies to a specific class of Indian children, because we do have some children who may be American Indian by race, but not by the specific political status. And I've lost track of my time. I think I may be coming up on time, so I'm going to go ahead and stop there. But I will note that this case is ongoing before the Supreme Court. I'm happy to talk to anyone about it. Turtle Talk blog, if you just Google that, has great resources on the case. It's called Brackeen versus Holland. And thank you so much for your time. ICWA is still good law in the US.
Well, I'm going next. So again, I'm really happy to be here. Citizen of the Navajo Nation on my mother's side of Milagana, of primarily English descent. On my father's side, my clans are the Towering House and Blackstreet Woods people. And I think I can be tech savvy in here. the few people in our audience, something to kind of look at. I'm really grateful for the background that both Lauren and Neoshia provided, because a lot of times when I'm speaking at conferences across the US, people don't know anything about Indian country or federal Indian law, and they don't even know these kind of basic things like, how does the US Declaration refer to Native Americans? You know, and I'll put up a multiple choice question like, is it Indigenous peoples? Which a lot of people are like, oh yeah, that sounds really good. Yeah, that was good. And I'm like, wrong, it's merciless Indian savages. And just that kind of right from the beginning, such a historic, important document in the United States. And that's how we're setting out relations with the Indigenous population at the time. And then same thing, right? Going through how many federally recognized tribes are there in the United States? No idea. And I've had people answer with 10, some people get the 574, and then equally I get like 210, right? So just this real basic lack of understanding that the average American has about the people, the original people of the country. And if you don't have that basic understanding, how can you even engage? How can you know what's important? How can you use your voting power to be an ally or support and to promote rights in the United States for everyone, right? Really challenging unless you have that basic information. And something that did occur in the last couple of years was a ton of media attention on tribes because of COVID. And a lot of stories covered my own tribe, Navajo Nation. There were stories popping up, a lot about Pokey as well. And it originally started with looking at, oh my goodness, these COVID rates are through the roof in a lot of these tribal communities. Many people were dying. And at the beginning, you know, especially for me, right, I said, if you're a native, you knew someone who caught COVID. And then now towards the end of the pandemic, you know someone who's passed on. It's deeply impacted every tribal community, every Native American in our country. And early on, the CDC was in their initial report, subsequent research, they were pointing to this connection between water access and COVID incidence rates. And it just makes sense, right? Like CDC saying, wash your hands every 5 minutes, wash your counters, wash everything, wash your babies, wash your windows, wash your cars, right? Like, but that takes a lot of water to do that. You need affordable access, regular access to clean water to do that. And there's a wonderful report that also came out, I want to say 2019, maybe 2020, by Dig Deep and the US Water Alliance on water access in the United States. And they highlighted a story on Navajo Nation, and based on their research, they connected lack of water with race, not with your socioeconomic status, not where you live in the United States, whether it's rural or urban. It is race as the greatest predictor of whether you will have clean, safe, affordable water access in the United States. And not surprising, Native Americans are the group to suffer the most. And so Latino and Black households, yes, twice as likely as white households to not have indoor plumbing. Native American households, 19 times as white households. And then if you get to specific tribes like Navajo Nation, it was 37. And so very startling, right? And but we were seeing a lot of attention on COVID, a lot of connecting between lack of water and these COVID incidence rates. Not as much discussion though about why tribes were facing those conditions. Because again, if you talk to people who are from those communities, it's not like we had water 2 years ago and it suddenly disappeared. It's been decades that we've been dealing with these conditions, hundreds of years, more than 100 years. And what I'd like to emphasize is everything that Lauren talked about, everything that Neosh mentioned relates to why there's lack of water. Because these federal Indian policies that were implemented by the federal government were all aimed about taking away from tribes, moving them on to the less desirable lands. And that report that Neoshia commented on just came out from Bureau of Indian Affairs that Deb Holland initiated with this investigation into boarding schools. Right at the beginning, they confirmed the boarding school era was a targeted effort by the federal government to assimilate, take the children, and dispossess of native land, right? And so all of these policies created the current day conditions that tribal communities are dealing with. At the same time, taking their children away, you took away their future leaders. You took away that future engineer who was going to help oversee the water plant. You took away that teacher that was going to motivate the kids to go. And through every aspect of tribal life of who we need to survive, our capacity to do that was diminished by the federal boarding era. So we're left with these conditions that don't exist anywhere else in the United States. Infrastructure, not just to water, but the road conditions, the broadband, when everyone else hopped on their internet to go and work remotely, that was really challenging for many tribes to do. The food deserts that also exist, right? Again, Navajo, this came out in the news stories, 3 to 5 grocery stores for a place that's the size of West Virginia, right? All of those conditions, how can you deal with that if you have also crippled our communities in terms of our capacity? And so we're still healing from that. Right, so just kind of summing up, and I think it's been mentioned throughout this week too as well. I love the U.S. Commission on Human Rights, their report, because it very clearly states how the federal government has failed in their duties. But the prior report in 2003 did the same thing, and nothing seems to happen. So it's kind of like, yes, great report, and then it kind of gets put on the shelf, and they'll write another one in a couple of years. But it's, again, for me, though, that report, I share it every time I talk because I tell people you have to educate yourself on this. If you want to learn more, there are many resources out there so you can understand the challenges that tribes are facing. And also looking at this list, the issues that were discussed previously, the issues Dean Kronk Warner is going to discuss next. There are so many challenges that tribes are dealing with that it's hard to address every single one because of those lack of resources, because of the diminished capacity. And so by necessity, again, we see this tension between tribal sovereignty, wanting to exercise that to the fullest, and yet being dependent on the government because of conditions they have created. And so these are all issues that we're still dealing with, and again, still healing from, right? Historical trauma, maybe we can do this in the discussion part, right? I mean, another challenge tribes are still dealing with from all of these actions, not just the relocation of boarding schools, but again, many, say average American would not know about the forced sterilization of many Native American women. And that was done by the Indian Health Service in part the agency responsible for elevating and promoting the health of Native people, and just this whole legacy of how energy has been developed out in Indian country. Again, just really wanting to highlight that there are many challenges faced on reservations, and they have not been fully resolved or dealt with, or in some cases even acknowledged. But what I want to spend the rest of my time talking about is water. Our tribal leaders across the United States have recognized the sanctity, importance of water, and connected it, you know, first, this bottom quote here is by President Nez, you know, clearly saying in the West, water is a challenge. We're dealing with extreme droughts right now, but no lands can be a permanent homeland without an adequate supply of water, especially potable water, right? Daryl Behill is the Hickory Apache Nation, their water resource director, again, right? That clean water is this basic necessity for the health and prosperity of any community, and yet so many lack them. And then the Southern Ute tribal leader, Chairman Frost, you know, connecting it to their treaty that they signed with the federal government, that the Ute band signed this treaty back in 1868. And that treaty promised them a permanent homeland to support them forever. How in the world can you have a permanent homeland without water, right? I just love that fact that tribal leadership has always known, but the US sometimes has forgotten. And so much of my work over the past, I can't believe it, almost 2 years now, has focused on water access in tribal communities. And when we started this work at the pandemic, which was really triggered by the pandemic because of the media attention and, you know, what those of us who are Native, our families were experiencing, those of us who were not, what their colleagues were experiencing, we initially started out just trying to understand the problem more. Because to be honest, when I went into it, and many of us thought, oh, this is a lack of piped water problem. If we just get piped water delivered in homes, right, that's the goal. And as we surveyed, we started with the Colorado River Basin, which is 7 states, kind of Utah's included, and it goes down over into Colorado. And within the basin, there are 30 federally recognized tribes, again, spread out from the basin. After looking into the different circumstances that each tribe was experiencing, we found out it was a little more complicated than just pipe water delivery. And so these are the 4 different areas that, based on our research, we found you need to obtain and maintain into the future to have water security. And the first challenge is, you know, again, clearly no piped water. I'll talk about these each briefly. Inadequate water quality infrastructure, and then the shorthand you'll hear if you get into this O&M. I call it operation and maintenance. And so the first one, right, this is what the news really highlighted. Native Americans more likely to lack piped water services than any other group. And Navajo Nation was, and still is, the classic example, because an estimated 30 to 40% of their homes do not have piped water delivery into their homes. And instead, these households are having to go to either a well or a local community source point that's been developed to haul water. And amazing principal hydrologist at Navajo, Crystal Toy Cordova, has the best picture of someone from right by where her parents lived. They don't have a vehicle, right? One of the challenges Neoshia talked about. And they have a wheelbarrow, and they have different various containers they put in this wheelbarrow and walk the 5 miles or so once a week to fill up those jugs, turn around and walk back. And that's their water source. And so again, think about that. You have a wheelbarrow full of water for a week during COVID that has to be used for all your domestic needs, cooking, showering, cleaning, right? Really challenging then to follow all these safety public health precautions. And it's not just Navajo that has families hauling water. Southern Ute also has a couple source points that their tribe had developed for families to travel and get water. And then, you know, again, like Hope, because you'll see Hopi is unique. They're totally surrounded by Navajo. So a lot of their community members also experience some of the same challenges that Navajo does. So some water haulers there as well. And then a couple other communities. But it was really Navajo Nation, Little Southern Ute, and Hopi, but not as many of the other tribes. When we spoke with, you know, both federal government employees as well as tribal administrators, they're like, yeah, we have water coming out. You know, the Southern Paiute, they had water delivered. Some of the California tribes, you know, maybe family here too, but nothing to the magnitude that like Navajo was facing. And the last thing I'll point out is, again, a lot of research as well about the cost of hauling water. Staggeringly higher, not just in turn, you know, like your time it takes, but it will be much like something like, again, almost like somewhere between 50 and 30. We have a report, if anyone's interested, it's on tribalcleanwater.org. We have a couple reports we've issued that have all the stats down. Okay, but the second area here then goes to quality. So you have pipes delivering into your home. That's great, right? But you turn it on and you can't utilize that water because either it's actually going to be dangerous to your health to do it, or it's just not good quality. Like it smells funky and it tastes bad. And this happened with one of the Navajo communities where we turned on the spigot and it came out brown. And the community members were like, we don't want to drink this. And EPA said, sorry, we don't need to do anything about it because technically it meets the water quality standard. It's just a little high in iron, right? And so we're giving this like deficient quality water out to our community members. But again, in other cases, it's not just that it's, you know, again, color is diminished a little bit, but it would actually be unsafe to drink. And Hopi is the classic example. And a lot of stories also have covered Hopi's water challenges. And it's just fascinating to me that it all stems from when the BIA put in their original system into an arsenic-tainted aquifer. And it's naturally occurring arsenic, right? But ever since the original systems were put in, they've been dealing with these arsenic challenges. And then on top of that, here we are, this is just a few years ago, EPA was then fining Hopi for not being compliant with arsenic. And I mean, what a mess, right? And I think the Hopi chairman estimated that 70% of people living on Hopi land were drinking arsenic contaminated water. Mm. And it was actually towards the end of the Trump administration, because there's a lot of testimony. The tribal leader went out to Congress a couple times testifying about the arsenic tainted water challenges and just the risks that it was putting on their community members, the observed rates of increased diseases and health problems that they've been experiencing, that the government kicked in like $5 million on the Hopi arsenic mitigation project that they're working on. And the last time I talked to EPA, they're like, we think we'll have it fixed by like 2023. So we'll see. It's always the follow-up that you have to do, right? Because you look at Navajo Gallup Water Supply Project, which was supposed to bring water, and that's been taking like, I don't know, 20 years. So yeah, but this water quality is a real challenge. And there again, also is data showing that tribal water systems have much higher quality violations than non-tribal. And you know, again, much of my research focused on the West here and the basin, but some of our Plains tribes also, there's a research that was completed where they tested different wells that the community utilized. They found that they were also high naturally occurring contaminants, and yet the communities had no other water source, and so they were using it anyway. And then connecting back to kind of the traditional energy development, Ute Mountain Ute, there's a mill near their White Mesa community in Utah, and a lot of their community members have been very concerned about these uranium mill tailings leaking into their water sources. And it was New Mexico did a study last couple of years testing Navajo mothers and their children and finding traces of uranium in the babies. And so these, you know, it's poisoning the lands, and these community members where you don't have really stringent, you know, testing of the different water sources. And even when you know a water source is tainted, no ability to mediate that, it puts these communities at really high risk of contract, you know, shortened lifespan, all sorts of like health issues associated with it. So quality, that's the second challenge, water quality. And then the third relates to infrastructure. And so in the United States generally, there's this association of engineers that has rated our infrastructure with like a D+. So across the United States, infrastructure is aging, it needs to get replaced. And the problem is even more so in Indian country, that these systems, even if, and this is a challenge, this was a big, so as I'm going through this list, it's getting to like more and more tribes are facing these issues. And as Andrew mentioned, Native Americans are one of the largest or fastest growing populations. And so the current infrastructure on their lands, even if it's delivering out to homes, the water quality standards are being met. It's not sufficient for the growing community. And so they need to expand their systems. In other tribal communities, there was a chairman from a tribe out in Washington state along those coasts. He said their pipes, some of them were still made of wood and clay. Like unbelievable. And so you have this two kind of components, one where it's outdated, it's failing, and you lose a lot of water when infrastructure ages. And so in the West, that's a big deal, right? When we're dealing with our droughts, like every drop matters. And so it's not only just wasteful, but it can also cause water quality challenges. And then that second component of just not even meeting the demands of the growing community, they need to be expanded out. And so this is a little map. The Indian Health Service, they maintain a database, has a lot of acronyms involved in this. You might hear it called the STARS database. But this, within the STARS database, you have this home inventory tracking system, their HITS database, and it's not, it doesn't identify every single Native American home in the US with water deficiencies, but it does identify many of them within Indian country. And they primarily rely on the tribe to tell them when there is a home that needs to be added to the database. So again, IHS does not have a mandate to go out and survey, but they do maintain this. And if tribes tell them, or when they're out in communities and they see homes, they add it to their database. And based on this database, you can see they designate homes between a deficiency level of 1 to 5. And the 1s will be those little yellow dots, and the 5s are the reds. And the 5 means there is no water or sanitation system at all. So you can see that really that Southwest, a little bit down there, like Oklahoma, Alaska, really, really challenging problem up in Alaska. The little yellows, those ones, means that the system, they have a water and sanitation system. It's meeting the standards now, but it needs a routine maintenance or upgrade. So if they don't address it, it's going to turn into the orange or, you know, ultimately fail. Okay. And then finally, operation and maintenance. And this one, I got to tell you, it's a little challenge. Like it was after you talk with the engineers and you get into the weeds of it a little bit, because it wasn't something on our radar at all when we started this project. But it makes sense again, right? If you put in a system, a water system that's delivering out, you have to do tests to check the quality. You have to operate it on a daily basis so that people are getting clean water, and you have to maintain it. So when there's a leak or you catch all this, that whatever line over there has this issue, we have to address it. Like that's what just the general operation and maintenance of water systems has to be done, or else the system falls apart. People aren't going to get water. And the challenge with O&M for tribal communities is directly related to that capacity component, that many tribes don't have the capacity to operate and maintain systems. And sometimes it's because it doesn't make sense to. We're a tiny community. That would be a huge expense on us. We don't want to operate and maintain our own systems. We want this third party to do it, or in some cases, the government has taken on an obligation, like BIA is actually operating and maintaining a water system. But in other instances, it might make sense for the tribe to want to take on that responsibility. But even if they don't do it themselves, they need to make sure someone's doing it. And that was a really interesting challenge that Hickory Apache Nation faced when they, as part of, they got a congressional act passed that to build a water system that the Bureau of Reclamation was in charge of building. It was completed. The tribe took over operation and maintaining that system for a little while. And then their division just fell apart. And then their water system became at risk, and they needed the government to take it over again. And so there's a lot of complicated things in O&M, and to simplify it, at the end, it comes down to money. Do you have the money? Because these are expensive things. You need water operators who have to be trained and all, you need people. And as was mentioned at the very, very beginning by Lauren, tribes don't own their land in the end. So there's a lot of revenue that's lost out on not being able to tax their lands. And so tribes that have other revenue streams are more successful and able to do O&M. Or if you look at Navajo Nation, when they established the Navajo Tribal Utility Authority, their electricity operations, their electric operations, that costs less for them to do. And so they're able to offset their water kind of operations with the electric component. And so it works for them, but not every tribe may be able to do that. And so this ongoing O&M is kind of this second next step of what we're looking at. Okay, because IHS is the only federal agency authorized to provide support for O&M, but they have never been appropriated funds to do so. And instead, there's these little hodgepodges with different agencies of where they can do technical assistance or say water operating training, but they're like smaller programs, and you're looking at several different agencies. So it's a little complicated, but the capacity really needs a lot of help. What I want to skip to in our report, we highlight, these are really the four main federal agencies. And I guess what I'd say to put this in perspective is that the United Nations in 2010 passed their General Assembly passed a resolution recognizing the human right to water. And just a couple years following that, California was the first state in the United States to recognize the human right to water. They have passed two bills related to it, just two statutes. And they are really the leader in this area in terms of states. No other state in the US has done it yet. Virginia got close. They introduced a bill, but didn't get passed ultimately. And California is pushing these big initiatives to ensure that every single California, and being very conscious and including the indigenous peoples of their state, will have clean water access. So, but all these other states aren't doing that. And so instead, in the US, because the US with, I don't know, the UN we acknowledge, UNDRIP, we Declaration of Rights of Indigenous People, but haven't really gotten any enforceable duties. So instead, in the US, we actually do have, we've already very strong treaty and trust responsibilities to water for tribes in the US. And that's recognized, and the government doesn't dispute that, because you have all these federal agencies with programs specific for tribal nations. And I spoke with federal agents at each of these agencies, and they all said, yes, absolutely. The US has an obligation to provide clean water and sanitation to tribes, and here's our programs to do that. And IHS is being the biggest one. It makes sense because of the connection between water and public health. But historically, all those programs were never funded, and so the government really wasn't fulfilling its treaty and trust responsibility until the Infrastructure Investment and Jobs Act came up. And for the first time, IHS, based upon that database I showed you before, they got the full funding of the homes and deficiencies identified in their database. And so that's a $3.5 billion number, and they'll get it over the next 5 years. There are also increases for EPA. They have some programs on these. They're like tribal set-asides with the state revolving funds for both clean water and sanitation. Those got bumps ups. And reclamation really comes in when they're directed by Congress to do so. But the $1 billion they got, that's still great, so they can wrap up these legacy projects that haven't been finished. The one that's missing from here, and where a bill is currently going through Congress, is USDA, U.S. Department of Agriculture. And they're my little overlooked heroes, because they operate on a real local level within states and then parts of states. And so they have these community partners where tribes can connect with them. They're really able to do amazing things. And even though they don't technically have a cap on the project amount, they say they do, but it's not a real one. Which again gets to problems like, why should the government say that if it's not real? Anyway, so the point is there's still improvements that can be made to each of these programs, but this influx of money is going to take us a long way. And what we've been pushing for is getting these agencies to collaborate with one another. Because if you have an infrastructure project, it's going to have all those different elements to it, bringing in pipe, dealing with a quality challenge, maybe expanding a system, and each of those different agencies have money that could be utilized on a certain portion of a project. And so if you combine together with the different expertise, we're going to be more efficient. We're going to be able to make that funding go further. So that's what we've been pushing. Again, the SAFER program in California is really interesting to look at, because they've just been the most progressive of any states in the US. And if you want to contact someone about California, my good friend Rita is an amazing person to talk to about that. So yeah, sorry I went like a million miles a minute there talking, but we can chat more later, or again, check out the tribalcleanwater.org. Okay.
Well, thank you. So I'm gonna take about 5 minutes because I want to leave time for questions. So I'm gonna necessarily go through this a little bit quickly, and I'm gonna use the law professor prerogative of see my articles that I've written on this. So, but if anybody has any questions later, I'm happy to answer it. So my topic is really how this all intersects with climate change, and it dramatically intersects with climate change. So you heard Lauren in the first presentation talk about gender violence and the dramatic problem of missing murdered Indigenous women across North America. And that directly intersects with climate change, because despite what you may hear on the news, is we have climate migrants within the United States. We have climate refugees, and they're overwhelmingly Indigenous peoples. So these are peoples at Port O'Shane in Louisiana. These are peoples in Alaska, such as the community of Shipmarish and Kivalina, where the communities have literally fallen into the ocean because Climate change has eroded the sea barrier reefs that protected them. And they've also, climate change has also increased the intensity of storms. And so they're literally losing upwards of a foot every year, which those of you, if you have a science background, know that rate of erosion is astounding. So we have climate refugees. So what does that mean? Of course, anytime you have somebody who is a refugee, they are at dramatic increased risk of sexual assault and rape. And also going to Professor Roemer's presentation and her point about how poverty has been criminalized, you're dramatically increasing the likelihood that you're going to lose your children, because you have food insecurity, you have housing insecurity. And then of course, the point that Professor Tanana was making about water, a lot of our tribes have been moved into land that is in severe drought. So in Utah, where we live, for example, you might have seen the New York Times story where we've lost so much water that the Great Salt Lake is literally disappearing. And all those chemicals and everything that have settled at the bottom of the lake are now being thrown up in dust storms, and they equated it to nuclear disaster. Right? These are the type of situations, and this is happening all over Indian country where we have these dramatic losses of water. And she did an excellent job of talking about how water imperils members of our community. So climate change is something that dramatically intersects with each of these topics that we've already talked about. And many in Indian country are uniquely vulnerable for two reasons. The first, a lot of us have cultural and spiritual connections to land that, while not necessarily unique to Indigenous populations, is pervasive throughout our communities. So for example, in my tribe, I can't engage in summer ceremonies here in Lisbon, Portugal. I have to go back to the territory of my tribe to do my summer ceremonies. So unlike other religions like Judaism or Islam or Christianity, where you can practice those faiths wherever you may be in the globe, our land is inherently relevant to our cultural and spiritual practices. And so as we lose the land, or as that land becomes inhospitable, as Professor Tanana was talking about, we've lost a lot of those opportunities and connections, and dramatically impairs us. We're also somewhat uniquely vulnerable because of our legal connection to land. Unlike other communities where we can put wealth to the side, right? This is all a question of money, as Professor King has said. But theoretically, if it gets too hot in Lisbon, you can up and move to Porto, right? You can move closer to the coast. You can move someplace a little bit cooler. But in Indian country, if we up and move because of the negative impacts of climate change, then we're losing a lot of legal rights. We're losing our rights to reserve land that has been set aside. We're losing our rights to use fructory rights, the right to use land, hunting and fishing rights, etc. So that legally imperils us. So as a result, climate change is certainly something that we're all dealing with, right? It's hot here in Lisbon, these heat waves. And so that in and of itself is not unique, but how it intersects with these other issues and the unique vulnerabilities of Indian country, I think are important to mention. So I just want to talk about a couple of thoughts of how we might address this both from a domestic US perspective and from an international perspective. So first, from the domestic perspective, and this goes all the way back to Professor Schilfgaard's presentation at the beginning. Remember that tribes in the US have quasi-sovereignty, right? We are domestic sovereign nations. And so that means that we have the ability to enact tribal laws that do not directly interfere with federal laws. And that is relevant to climate change in a couple of ways. First, many tribes have adopted climate change adaptation plans. So the impacts of climate change, well, climate change is negatively impacting all of us around the globe. How we're each being impacted is a little bit different depending on where we are. And so a lot of adaptation planning is inherently localized. And so tribes are doing this work, and tribes are doing a great job. I always like to use the example of the Confederate Salish and Kootenai tribes, which are located in Montana within the exterior bounds of the United States. And the reason I like to is because they've used their traditional ecological knowledge. They've lived there for centuries. And so they know how to preserve the resources of the area, and they directly put that into their climate change policy, which I love. And I think a lot of other governments could learn from that example, because other communities have traditional ecological knowledge as well. And if you want to learn more, I wrote an article on this in the Colorado Law Review about tribes as innovative laboratories for change. The second thing that I think tribes can look at for domestic solutions is specifically to treaty rights. So again, Professor Van Shielsgaard talked about treaties in the United States. So the relevant portion, there are several treaties that specific tribes, and this is a specific tribal enterprise, have, where it talks about the federal government's obligation to protect a certain resource. And so in those particular instances, so for example, in the Northwest of the United States, a lot of those treaties include provisions to protect fisheries because the tribes were directly reliant on the fisheries. So where there's that type of language, and if you have climate change imperiling the resource, which you certainly do in terms of fisheries in the Pacific Northwest, there may be an argument based on treaties that tribes could use to argue that the federal government has a duty to protect the resource. So it's using treaties to protect against climate change impacts. And if you'd like to read more, I wrote about that in the Nebraska Law Review, What's Old is New Again, looking specifically at the treaty question. Third, tribes have really developed this interesting argument that is not unique to tribes. Many indigenous peoples around the world have used it, and also many countries around the world have used it, such as in Pakistan, India, and in portions of Latin and South America, but that's the right to nature. And so what we've started to see is several tribes in the United States, so for example, the White Earth Nation, have specifically recognized a right of nature for certain resources that are imperiled by climate change, which gives that natural resource the right to bring a claim. So the example of White Earth is Newman or wild rice, which is being imperiled by climate change. And again, using that inherent sovereignty to adopt and codify that right. International law, I'll be really brief because I want to have time for questions. The first is self-determination, and the second is free, prior, and informed consent. So self-determination, many scholars have argued, have risen to the level of customary international law. Under international law, we see it codified in the UN Declaration on the Rights of Indigenous Peoples at Article 2. And specifically, it allows for people with common political and cultural organization to have the right to self-government in territory. So that obviously intersects where climate change is negatively impacting the ability to govern and the territory and all these other issues that we've talked about today. Second, under international law, free, prior, and informed consent. You also see that in the UN Declaration on the Rights of Indigenous Peoples. It allows for Indigenous people to give or withhold consent for a project that may affect them or their territory. This, of course, is relevant to climate change because a lot of industrialization and development creates gases which perpetuate climate change. And also many of our mitigation strategies that the global north are using negatively impact and destroy Indigenous communities. An example of this is REDS, which were developed by the global north and are being implemented in many Indigenous territories, such as in Brazil, where the Indigenous peoples there have fought against them. So those are some thoughts on domestic strategies and international strategies. And we have 4 minutes. So if anybody has any questions, we would love to hear them. Yes?
So I'm really interested in your goals here with the reference to UNDRIP, as we call it in Canada. So in British Columbia in Canada, we have now a provincial government that has mandated that their laws must conform to the standards of this international declaration. And the consequence, where I live on one of our major lakes, it's like 70 miles long, 2 miles wide, is that First Nations now have the right to define the water management laws, and the province and the federal government must work to meet those standards. Now, this is just a very tiny beginning. I am somewhat optimistic, but cautiously so, given our colonial history. But I'm wondering, do you see the manifestation of anything like this in the US, and if so, where?
Yes, so we do have a similar system in the United States as tribes as states under certain environmental provisions. So the Clean Drinking Water Act, the Clean Water Act, the Clean Air Act, all have these provisions in it which say that the United States uses a federalist system where the federal government establishes the minimums, but then the states can decide how to meet those. And so, for example, under the Clean Water Act with the TAS provision, the tribes can apply to act as states where they get to decide how the water quality is met. But the difference is, from what you're talking about, is it goes back to Professor Van Shiftgaard's introduction, where she said that tribal sovereignty is perilous in the United States because it's not based upon UNDRIP, the UN Declaration on the Rights of Indigenous Peoples. It's based upon the Environmental Protections Act, or agencies, view that tribes are separate sovereign nations. So, which comes from a 1984 policy statement. So theoretically, you could get a new EPA that comes in and says, nope, not doing that anymore, which goes to her point that she made at the very beginning.
And I guess, you know, that's why I say Canada, I'm cautiously optimistic, because there's a lot of resistance to these kinds of movements, and if our government changes. So this would change. But what I think might be the difference in what I'm experiencing where I live is that the laws that are mandating water management in this particular country are the laws of the First Nations, not the province and not Canada. But now the province and the state are obliged to meet that legal standard that's been set by the First Nations, not to set their own standard. And I think this is a significant shift.
Yeah, it's definitely a positive shift.
Yeah, I mean, I haven't added anything to that except to say that the challenge I think we primarily face in the U.S. I'm not really scared that TAS, even as states for tribes, is going to be taken away. But we have few tribes who are exercising that power the same way that we talked about under the VAWA, the Violence Against Women, how and the Tribal Law and Order Act, tribes have ability to actually do a fair bit in theory, but we've never seen that full potential because tribes don't have the resources to run their own tribal courts and things like that. And so I don't know if, you know, we had tribes fully exercising that ability, would we then start seeing some hampering down? Maybe, but you know, we have cases in the US, like our classic textbook for law students is a tribe that set their water quality standards and a city had to meet those. And so it can potentially have these off-reservation effects. But for me, that the biggest challenge here is how do we build up our capacity for tribes and dealing with this past so that they can actually maximize the full authority that they can. So I don't even think we're doing that yet.
And that obviously is
yeah. Well, Trevor, did you have a quick question?
I know it's quick. So one of the things that was brought up was pastoral work today, potential implications of having kind of a concurrent jurisdiction framework. And that's really what the U.S. Supreme Court wants to see going forward. I'm curious what that could potentially do, of course, in ICWA, as you were saying. I'm also curious what that might do with environmental protection because tribes have had the benefit of, you know, I guess in terms of securing their rights having to go through states, but also having a lot of federal leverage being able to kind of on their own, especially with environmental. So I'm curious if there's any potential.
Professor Roemer, did you hear the question? So the question was, how does the recent decision in Huerta potentially impact child issues around ICWA? And then it was also same and environmental, but maybe 1 minute on ICWA.
Yeah, that's a great question. And I'm going to exercise my professor's prerogative in that I'm currently writing a paper that speaks to that somewhat. You know, I think what's going on in the Supreme Court right now with the Dobbs decision, Castro Huerta, and Brackeen, it's all connected. Because if we think about reproductive justice and what that means, you know, the right to have a child, not to have a child, and to parent in a safe and healthy environment if you choose to become a parent, it's all connected. Especially, you know, this idea in Castro Huerta, two things. And the thing I find most problematic isn't necessarily the holding, which is a problem. But there's a phrase in that opinion that, you know, emphasizes tribes are a part of a state. And Professor or Dean Washburn in the recent ASU, was that Trevor that asked the question?
Yeah, Trevor Reed,
yeah. So at the recent ILP forum, you know, Dean Washburn, you know, spoke to, you know, well, tribes have always been a part of states because, you know, Choctaw Nation of Oklahoma. So I take that point, but it is a little, I have some red flags in my mind about, you know, tribes are part of states and what that means for child welfare. And by the way, many of these states that have Indian country locate, or I should say larger portions of Indian country located within their boundaries, they tend to have pretty good working relationships with child welfare agencies and services within the state. So there are a lot of working relationships already going on, but in terms of what it means, should Brackeen or how it might influence Brackeen, I again, red flags around that. Tribes are a part of state language.
That was exactly that same line that terrified me, honestly, because even though the case is narrowly focused on criminal jurisdiction of a non-Indian, right? Where it could go from there based on this tribes or like that kind of underlying reasoning really made me nervous. And just this push for really elevating states over tribes and letting states impose on very, it's like look at these Montana exceptions, these are, all these things fit in with the safety, welfare of the tribe and sexual relationships and then what the court has done is just shocked me. And so I honestly, when that came out, I had a very, in my stomach about where ICWA would go. I really, really hope I'm wrong, but it just seemed to elevate states above tribes and say their interests are more important.
Yeah, and I would just add, I'm just waiting for the second Montana exception to be struck down. So we have this case, United States versus Montana from 1981, which sounds like maybe you're familiar with. And it says that in general, tribes don't have the ability to regulate non-Indians on non-Indian land. But if one, they consent to it, they can, which I don't think is imperiled. But two, if it threatens the political health, safety, and welfare of the tribe, then the tribe can regulate. And so in the environmental world, a lot of tribes have relied on that second provision, because you can think of many ways that environmental pollution imperils the tribal entity. And I think this line, just going back to what's already been said, this line that tribes are part of the state just further puts that at risk, right? So I think, I'm just kind of waiting. I'm hoping that I'm wrong, but waiting for that second Montana, for the court to say, oh, no. Unless the non-native specifically says consents to jurisdiction, tribes can never have jurisdiction. So,
and Lauren brings up a little point about the Cooley decision. It's kind of flip up, because so Cooley, I don't know, Lauren, you want to add what do you think? How are these going to settle out?
Oh, I don't think you're wrong. I think that the court definitely thinks that tribes are antiquated and that the time has come for us to close that chapter. But I think they run into a real problem where they're also really pro-carceral state and pro-police. And so you get a case like Cooley where it's but you tribe police officers. And so I think that with Cooley, they held that the tribes have a jurisdiction to search a non-Indian vehicle, but it was curiously under the Montana 2 exception, which was the first time we had the Supreme Court make a holding on Montana 2, which was great. And so hopefully they painted themselves in a corner. And it's one of those things where tribal sovereignty is not necessarily a partisan issue, and it very squarely impacts our notions of sovereignty generally, which include the sovereignty of the United States. And so the ways in which we characterize tribal sovereignty, including this tendency to think of it as antiquated or decaying, threatens the US itself. And I think that Indigenous people really need to highlight that it's not just our sovereignty, it's all of our sovereignty that is impacted, right? It's a real rule of law question.
Yeah, but they don't care about that anymore.
It's really frustrating. They just don't.
Right.
Well, I think Roberts wants this post-racialized world. And so I think this is the pessimist in me, but I think we'll see Brackeen go down, Indian Child Welfare Act go down on racialized protections. And then once that's gone, then tribal sovereignty is on the cutting block. But that's just, I very much hope I'm wrong.
Well, I think they're pushing states' rights to the extreme. Because that's what I raised my hand to say, but Lauren, I mean, covered it. You know, Cooley was very much about public safety. When it comes to things like public safety and the powers of the police, they're going to protect that. But when you look at a non-Indian law opinion like Dobbs, which very much impacts Indian peoples who, anyone who has a reproductive system, basically, the arguments about public safety, public health, they just kind of poo-poo those and put a footnote in there that's like, we need a domestic supply of infants. And like I said, I am writing an article on that I'm hoping to push forth in this upcoming fall cycle that talks about that a little bit more.
Well, unfortunately, I could stay and chat all day, but we have run out of time. So I want to thank our virtual panelists and thank you for coming. And thanks so much. We appreciate it.